Good morning to everyone present here. On behalf of KCC Institute of Legal and Higher Education, I, Nidhi Gandhi, Faculty of School of Management, welcome you all. Today, we have among us Mr. Shailendra Singh, Group A Gazetted Officer, Patent Office, Ministry of Commerce and Industry. It gives me an immense pleasure to welcome you, sir. We are pleased to have you with us today. Mr. Shailendra Singh has done mechanical engineer from SRM University, Chennai in 2014. He is a part of various missions and campaigns under the Ministry of Commerce and Industry and the Ministry of Education. Currently, he is working as Group A Gazetted Officer, Patent Office, Ministry of Commerce and Industry. He was awarded with appreciation by CGDT-TM for the exceptional work for the Patent Office in year 2017. Sir has delivered lectures, more than 120 seminars and national conferences in various institutes and universities across the country. Without taking much time, now I would like to request Sir to share his view and impart some knowledge. Over to you, sir.
Okay, so very good morning, everyone.
Good morning,
I think I'm audible as well as visible to you all.
Yes, sir.
Okay, thank you. So first of all, sorry for the late joining because of some maybe internet problem or some system error. I couldn't be able to join on time. So first, we need to understand that what is the basic requirement and importance of IPR for our educational system or for any type of businesses that we have today. So first of all, what is actually an IPR? IPR means intellectual property rights. So we have different rights like physical rights, like land, like we have buildings, like we have cars, like we have many other things. In the similar way, we have intangible right, that is intellectual property right. Now, this particular right is basically the ideas that we get from our brain. So the rights over the things, the ideas that we develop through the learnings from so many times and duration. So that is basically the intellectual property. Now, first we need to understand what are the different intellectual properties that we have in our system for the uh, registration purpose, because there are so many different things like we have patents, design, maybe there are many others. So we need to have the clarifications between the different IPRs, like under which category your intellectual property will lie. Likewise, like if you have made any device or maybe any product which has some different features or maybe different capabilities of doing anything, so you need to understand that I should file this thing in the patents category. Now, if anything is related to the outer looks of any products, then it should go with the design things. Any written article or any written thing or maybe a movie, video clip should go for the copyright protection. So like this, we need to first understand the different IPs and under which category your IP belongs. Now, the another thing that we need to understand the requirement of IP in the present scenario. Now, if you see that day by day, we are seeing so many people have started having their own businesses, their own companies, their own startups. Now, if I see some of the data of the past, like if we talk about 2016, now in 2016, we used to have around 500-600 startups in India. And recently, what I have checked in 2022 or 23, the current status is around 82,000 or 83,000 startups in India. So that is a huge jump that India has taken in terms of the startup, that people have started starting their own businesses, bringing their own ideas into the public domain, having new products, new technology. So that is very much important to understand that if you are going to start any business, then you should have the basic understanding of these IPs, because it's very much important for us if we want to protect our idea, if we want to have the monopoly over our technology, maybe a product or maybe any other art forms also. So this is the basic thing. Now, if I compare some important facts related to the filing of IPRs in other countries and India, then I will find out that in India, the filing is pretty low right now. Means if I compare with any other developed nation, India is still a developing nation. But if I compare that, having such a huge crowd in the country, having so many intellect people, but still the filing of the IPR is quite low. Now, if I say like 15 lakh patents are filed in China in a year, and if I talk about filing of patents in US, it's around 6.5 lakh to 6 lakhs. But in India, we have still not reached 1 lakh mark for filing of patents in a year. Recently, it's around 82 to 83,000 patents filing, and that is also have changed in the last 3, 4 years. So it's very much important for us to understand that it's very high time to understand the importance of these IPs, to understand that uh, it is very much important part of our that educational uh, field also, and in terms of what I can say, the in terms of uh, uh, business as well. So I'll share my slide. Just let me know whether it's visible to you. I'm just sharing my content. Is my slides visible to everyone?
Not till now. Yes.
Yes.
Okay, thank you.
Visible now.
Thank you. Now, first we will see that what are the different IPs that we have in our system. Now we have patents, design, trademark, geographical indication, copyright, semiconductor integrated circuit layout design. So these are the different categories. What we can say that under these categories, we can file the IP. Now, one important thing for us to understand that we should differentiate between these IPs because it's a very important part. So many people have a confusion in their mind regarding the patents filing, regarding the design filing, that what people think that patent is same as designs. But there is a very big difference between both of these categories. Now, if I compare, tell you something like how a company does the business, how they protect their technologies or their product. Now you can see some product on your screen. Like in this, this is an Apple laptop. So in this product, what we will find out that before launching this product in the market, what the company did. Company first of all find out the different IPs which are there or linked with this particular product. Now, if I say that all the technology that is used in the laptop, all the different parts, they are patented. So first is the finding the different category. Now, what they did, like let us assume that LED display in the laptop. Now that is a patented thing. Now, second thing is the design of the laptop, means the outer looks of any product. So the outer looks of this product comes under the design registration. So if I talk about anything which has a different design, means outer look, the aesthetics of the products comes under the design part. Now, third is the trademark, that is the logo of the laptop. Fourth is the different things related to the manual of the product, or maybe the algorithms used in the product, or maybe the programming used in the laptop. So these are what? These are the copyrighted things. Now the next thing that is the SICL design, means semiconductor integrated circuit layout. So the electronic plate inside this laptop basically comes under the SICL designs registration. So you can see and understand that there are 5 different categories of IPs which are there in this laptop, and you need to first identify each and every IP and you need to register them. so that in future, if anybody tries to copy that, you can file an infringement case against them. So that is a very important aspect for us to understand. Now, let us assume that this laptop made by Apple company, they have registered patent, trademark, copyright, and SICL design. They didn't have the design registration in this product. So what will happen in future? Maybe the people are buying this product not because of all other things. They are just buying it for the design part. That they like the design, the looks of the product, and that is why people are buying it. So what the companies, other companies will do, what they can do, they will copy that similar design and they will start producing or fabricating the similar design product. And in this way, what will happen? The market of the Apple company will go down. So it's very important for us to understand that the differentiation of IP is very much important. Even and registering each and IP, if your product is important to you in terms of means market, in terms of if you are going to sell it into the market, then it's very important to identify each IP and file and register them, so that you can have the monopoly and exclusive right over each and every part of this product. Now, what are the significance and importance of this IP registration? The importance and significance that I have already told you, it will help you in protection of the IP. It will exclude others from doing any business activity without your permission. It will help you in getting and earning from the IP. Now, one important aspect that we need to understand first of all. Now, I was talking about the business activity, about the commercialization of the product, about the companies, startup, and everything. Now, it's very obvious that is IP protection is very much important for the business category. But is it important for a common person also? Yes, it is very much important for a common person, means like an academician, like a professor, like a teacher, so or a student also. So it's very much important for us in very different ways. Like if I say, like if any professor or any person who is having different IPs, different patents, then it will create a greater impact in his academic or in her academic career also. Maybe because of that, they will get a better position in any institute, because it shows the intellectual level of a person. So it's very important for even the academicians. Now it's for a student, if let us assume that there are 100 students and they are going for an interview, and out of them there is a student who is having a patent or they have filed a patent. So what will happen if they have written this thing in their CV, like I have a patent over this technology? The person who is taking the interview, they will definitely show some extra interest, and they will definitely find that person much more innovative and useful to their company rather than the other 99 people. Why? Because everybody is looking for someone who has some innovative ideas, who has the capability to create something new. So it's very important for a student also to understand the importance of these IP registration, to have innovative ideas in terms of the present scenario. Now, if I say like we have seen so many applications from many institutes, like there are so many professors or maybe so many faculties who filed the IPs, not because they want to do the business with this activity. They also can do one thing that you must have be knowing, like technology transfer. You just develop the technology and transfer it to the company, and by just transferring you are going to get a reward, means, or maybe the earning also. So in a different way you are going to get the income from that patent also. So that is also a good thing that we need to understand by this IP registration. Now I will talk today about the patents filing and its procedures only, because if I say that it's a very long process of understanding the different parts of the IP. So I will talk majorly on the patents. I will give a brief on other parts also, like the designs and other things. but majorly I will talk about the patents and its filing and the different things that we need to consider before filing the patents. uh, I just want to know, can anybody share me or tell me what is actually a patent? What you know about the patents? Anybody from the participants?
Hello,
Yes, sir, please.
good morning, sir.
Yes, yes,
So,
yes.
for example, there is a chemical formula or the formula of making something, and that you get registered. For example, we make medicines.
Yes,
There is a
yes.
chemical formula for making the medicines. When we register that, that is called a patent, and it's in many fields.
Okay. Just
It's one example of
in
a
addition to
medicine.
that, in addition to that, I want to ask one another thing. Like, if let us assume I want to get the monopoly of any product um in India, maybe in two countries like US and India, then where I should file the patent?
Can you repeat the question, please?
My question is that let us assume that I want to get the monopoly or exclusive right of over any product, means patent I want, and I want to file it in maybe I want to get the patent rights in 5 different countries: US, UK, China, India, and Australia. Let us assume. Then in how many countries I am going to file the patent? Only in India, only in US, or maybe something like what I can say international,
One
or
country.
maybe.
Only in one country I can file for patent.
So according to you, if you file it in India, you will have the monopoly in other countries also.
Yes, sir.
Okay. So any other thoughts?
in
Any
in all
any,
in all countries sir. In all countries you have to file a patent.
There is
means
a
in all the
patent
different 5
cooperation.
countries.
There is a patent cooperation treaty, and according to that, if you file in that office, then that is valid around the world
Okay.
for the countries that are involved in the treaty.
Okay. 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 Yes. So most of the people have given the quite correct answer, but just a little bit of misinformation. Like first sir said that only in one country. No, so first thing that we need to understand about the patent. Now in this slide you will understand, like patent is a state right, sovereign or a state right, which is given to a person giving exclusive right to others from making, using, exercising, vending, and importing. So if we talk about anything which is a state right, it means it is valid only in that country where it is filed. So if I talk about that I want to do the business in 5 different countries, then I should have the patent over the different countries where I'm going to do the business. If I want to do the business in US, UK, China, Japan, then I should have the patent so that I can entertain my exclusivity of the product in all the different countries. So first thing, you need to file it in all the different countries where you want the exclusive right. So that is an important aspect. Now, second thing is that it is given for a period of how many years? Can anybody tell me? Patent right is protected for how many years?
20.
Yes. So patent right is basically a right which is given for 20 years from the date of filing. Means if you have filed anything today in Patent Office India, then from today onwards, after the grant, the date of filing will remain the same and the date of patent also will remain the same. Means if it is today, then it will be counted from today itself up till upcoming 20 years. After that, what will happen? Your product will come into the public domain, and whoever wants to use it, they can use it without your prior permission. So that is the second important thing for the patents. Now, for which thing we get the patent? For any innovative ideas or any product or any technology, basically we can file a patent. Now, one important thing, like you see so many inventors and scientists of the past. Now people have a thought in their mind, like so many ideas and so many innovations are already been done in the past. So what new thing I can do? So one important thing that we need to understand is that yes, there are so many ideas already being shared in the past, but we need to understand the importance, like in each and every field. When you start doing some more research, you will get to know some new innovative features, or maybe you can add some new qualities to that product. Like if I talk about a very simple example like telephone. Now telephone, the things is same, means the usability is similar. What we used to do with the telephone in the past to communicate with each other, now also the basic feature is to for the communication purpose. But what has happened in the last 10, 20, 30 years, like we have added new things to the technology. Like from the wired thing, we came up with the wireless system, or maybe with the satellite system, where we can connect with each other without the use of any wire. So that is the upgradation in the same technology. These upgradations are basically what? These are the innovations in that same technology. And these innovations are basically filed for the patent application. So that is the very important thing we need to understand. Now, can I know what is the one benefit when you share your information to the public domain? You got an idea, you shared with the people, means you maybe published your idea in any publication, or maybe you have filed a patent for this. So if you share this idea in the public domain, what is the actual benefit the society gets from that idea? Can anybody tell me what are the benefits that people will get when you share any idea in the public domain? When you bring your technology or maybe product in the public?
They can make improvements on it.
Yes, please.
They can make improvements on it.
Yes. First and the very important thing is that when you share any ideas, the people will get to know like this is a existing technology, and if anybody has a better idea, they will make it much more useful to the society. So that's the very important aspect that we need to understand. If we do not share the information with the public, what will happen? That solution will remain to your nearby people only. And because of that, if any new changes that is required in that system will not take place without disclosing that information to the other people. So that is very important part for us to understand. Now, some of the very few examples that you can see on your screen also, like patents, like this is a very simple example, like this hat. Now, this hat, what it is doing, it is protecting a child face from getting wet. So it's a very simple solution, but it's a very innovative idea that how you can protect a child's face from getting wet while they are taking bath, or maybe when you take them for the bath and they feel irritated because of that soapy water, or maybe the water when it gets into their eyes. So for that purpose, someone has used his creative idea to make this type of hat. So like these, there are so many other products also in the market with so many technologies which are useful to the people. Now the patent filing we will discuss now. Has anybody filed any patent application till now? Anybody filed any patent application till now? Patent application.
We have not, I guess, we have not filed, but I have one very related to this. One or another day,
Okay.
every second day, we get one message that this patent place is backend. If you want to attach, give your name, you can join us in this patent. And as per position में वो charges करते हैं, वो कितने relevant है charges?
So, first of all, we need to understand that if you are looking forward to filing a patent, or if you want to file a patent, there are so many thoughts that people have in their mind. Like, first thought is that, is there mandatory to have a patent attorney or agent in between the process for the support? So first thing is that it is not necessary to hire any patent attorney or agent or take any second person's help while filing the patent application. Why people usually take the help of these people? The thing is that we are not clear about the filing process. We are not aware that these forms are required for the patent filing. These this is the fees, these are the form, these are the timelines. So these things we need to know. And people are not willing too much to understand these basic things. Until and unless you start filing by yourself, you will not be able to understand the basic, which is a very simple process. First of all, it's not a very complex thing. The only thing is that you need to first start understanding that, yes, I want to file a patent. Which forms are required? These forms are required. I have to file it in these timelines, and that is all. Fees and everything you will get to know through the internet also. Forms also you will get to know, like these forms you need to file for the patent application. Now I will tell each and every form what is the requirement and why it is required in the process. Now there are many forms in the patent application, and each form is not required. But there are some forms which are mandatory for each and every applicant, and which are basically required for the complete process itself. Means if there is no modification, there is no any other changes, then these are the forms which will make your patent grant without any other requirements. So what are these forms? These forms are Form 1, 2, 3, 5, and 18. So you can easily search these things on the internet, like please tell me about Form 1 of the patent application in India. So you will understand that this is the Form 1. You can see the format also in the images of the Google. Like this is the Form 1. Like this, you can search out each and every form, and you can understand that this is the basically the form. Now I will tell you what is actually these forms. So Form 1 is basically required for the purpose of understanding the applicant details and the inventor's details. Like applicant detail, like let us assume that KCC Institute is an applicant. They are filing a patent application. In that case, you need to give the information of the KCC, like KCC Institute XYZ, Noida, Greater Noida, or whatever is the location, and other basic details of the institutes. Now, second thing is that who are the inventors? Now, KCC will not be an inventor. Inventor will be the maybe the student, or maybe the faculty, or maybe the researcher in this institute who are working. So who are the inventors of this application? That we need to fill in this particular form. The title of the invention. So these basic details you need to give in the Form 1. So first form is Form 1. Whenever you will file the Form 1, your date will be calculated from that date. Means if today you have filed a Form 1 for the patent application, then from today itself, all the dates and all the timelines will start from today itself. Now, second is the Form 2. Form 2 is basically nothing. It's just the descriptive part of the application. Means whatever you have made or whatever you have done in the in your research, like you have made, let us assume that you have made this mobile with some different features. So all the features, all the information, all the descriptions, all the technology that you have used, that you have developed, everything you need to mention in the Form 2. How it's working, how you are going to fabricate, what is going to happen, what challenges you have solved in this problem? Means, first of all, you need to understand what is actually innovation. Can anybody tell me what is actually an innovation or invention?
The act of searching something new or new technology or new thing which can enhance some performance as well as can do a different type of work or style of work.
Okay. Any other explanation? Sir has quietly said it quietly right, but any other type of explanation who can make?
Hello. Hello.
Yes, please, ma'am.
Sir, any new product, any improved product, any improved process, or anything new that you're bringing, that's called innovation. It can be an improved process also, improved product, or something new,
Okay.
or innovative technique of doing something.
Okay. Can you clarify what actually improvement does to a system?
Basically, innovation is to find the new method to solve any particular problem or improve the existing solution.
Yes, okay. So all the definitions are quite correct. So one basic thing is that there is a term that sir has said, problem. There is a problem in an existing system. Now that problem you are solving through that innovation, through that invention. That is basically the understanding that we need to make. Because if you understand this concept, like this is the problem in the past existing technologies and past products, and we are giving a solution by this technology, or maybe by this product, then it means that you are giving a new invention to the society, and these type of innovations will be filed for the patent application. So in the form 2, you need to give all the descriptive information in these format like title, background, particulars of the drawing, brief description of the drawing, brief description of the invention, claims, abstract drawings. So this format you can get from the internet also, like what is the format of filing the form 2 and description in the patent application. So that you can easily check on the internet. But these are the subheadings that each and everyone needs to understand, that in this particular format you need to file the application. Now there is a term, second term, background of the invention. Now this term is very much important in assessing your application. Now it clearly differentiates between the person who has actually done the research or who has just copied it from somewhere. Now, why I'm telling it? Because what happens when we study any invention from different inventors across the world, we will find out there are two types of inventors. One is that who has copied the things from somewhere, and because of that, they are unable to give the explanation over so many other things which are required for the filing process. And there are some people who clarifies it in just one line, and they just mention and focus on that one line. They just clarify that this is the problem and this is the solution. They clarify that this is the prior art. Prior art means previous technologies that we have, and this solution I have given over this prior art, and you also mention about the prior art also. So when you mention all this information, it clearly differentiates between the copied part and the person who has genuinely made the invention. So it's very important to disclose about this background of the invention, because when you do not explain this information, what will happen? Your invention becomes very generalized. And when the things become generalized, you will going to get the generalized opinion from the offices also. Means you will not be able to clarify, like let us assume that someone says that I have made a car which can help us in transporting from one place to another place. Now, if you write this information, like I have made this type of car. Now, this is a very generalized information because there are so many products with a similar utility. Now, what we will do in that exchange of this information, we will cite some documents with the similar information. Like I will cite a document with this, like there is a 4-wheel drive vehicle which will help us in transporting XYZ person to this place without any other explanation. Why we have not given any other explanation? Because you have also not mentioned or given any clarity over the inventive feature. You should clarify that this is my inventive feature. Like let us assume that you have used any specific technology which is not available anywhere, or maybe any mechanism that you have created by yourself. So in that case, we have to answer over that mechanism. We need to clarify the things over that mechanism only. We cannot give opinions or maybe explanation very means what I say generalized or maybe broad explanation we cannot make in that case. We need to give clear explanation over that mechanism only. So that thing is very much important for us to understand. So these differentiation we see in many people when we see applications from any any applicant who has filed or drafted the application by himself or herself for the first time. So these things they usually forget or maybe they do not know. When you file it from an experienced person or maybe from an attorney or agent, they know about these importance of this drafting process. Now, third thing is the Form 3. Form 3 is the foreign filing. Means you need to give the details of applications which are filed in different countries. Like if you have filed your application, like in the starting, I have started with, like, let us assume that I want to file in 5 different countries, any application. Then you have to give information about all the different countries. Like in these countries, I have filed a similar application in US, UK, China, Japan, wherever you have filed, you have to explain it and means you have to give the information in the Form 3. Next is the declaration as to inventorship. Now that is the Form 5. Now Form 5 is required because you need to give clarity over the inventors. Who are the inventors of the that application? Now in Form 2, there are 2 things you will find out. That if you talk with someone else, like in 2 different ways we can file the Form 2. One is the provisional filing and one is the complete filing. Provisional means your information is still going on, means you are still collecting the information, you are still working on your research, and your research is still not complete, but your idea is clear. So to protect that idea, you have filed the application, but the implementation part is still pending. So what you are doing, you just file the idea with some basic information, and the government in that case, what they will do when you file the provisional specification, they give you 1 complete year to complete the things and file the complete specification in that 1 year only. So in that case, what happens, maybe in the starting, only 2 people were there who were the inventors. Now, during the process of complete fabrication and all other things, you may require any other 3rd person or maybe 4 persons. So in that case, inventors has changed from 2 to 4. So in that case, after filing the complete specification, Form 5 needs to be filed with the disclosure that these are the inventors of the invention. Now last is the Form 18. Form is the request for the examination. Now, maybe you have not filed the patent application in the past, but you must have heard or maybe seen so many people displaying on the different website or maybe like Facebook or maybe Instagram or maybe LinkedIn, like I have got patent over this, my patent got published, or maybe you have seen so many banners on the roads like 3,000 patents published in the year, this university XYZ, or maybe you when you open up any university's website, you will find out that these many patents registered, these many patents published. Can you give me the differentiation between the publication and the grant, and which one is more important, or which actually means that you got the patent? Differentiation between the grant and the publication.
Actually the publication is the only the thing ki like the commission is approve is your patent, but grant is something different, right? So there are the number of the step between the patent publication and the grant, and it is not mandatory that if your patent is published, it is also be the granted. So the grant is, I think, is important. The publication is not important if you are filing any patent.
Yes, very good. So that is the thing. First of all, we need to understand, and each of us should know this thing. Why? Because so many people have a thought in their mind that yes, my patent got published, so I am going to get a patent over it. Means it is going to get grant. So that is not the thing. First of all, if you say that I have means lakhs of rupees to invest over the patent application filing. So what I can do, I just search out 100 documents from the internet and I can file it in the patent office. And all the documents are going to get published. Why? Because no one has scrutinized till publication. Publication is done just to give information to the people in the public domain, or to the different people in the same fraternity to understand that this is the information which is disclosed by XYZ person. And if anybody has any means issue with that information, if they find out that it is already they are using it, or maybe there is this technology, they know about it, so they can file a pre-grant opposition against you. Or maybe in other way, in positive way, if I say, your publication will help you in getting a business. How? Because let us assume that you have created something and your public, when am I audible?
Yes, sir.
Okay. So in the I was talking about the publication. So in positive way, if I say that publication, how it is going to help you out, when your when your information gets published and it is useful to a company, then what will happen? They will find out, each and every company always reach out the different inventions which are filed by the people or maybe the company in the similar field, like Toyota, Honda, or maybe Maruti, or maybe Hyundai, or maybe Mercedes, or all these companies. What they do, they definitely keep on checking all the patent applications which are filed by different companies in the same field. Why? Because they work in the same industry. They have the similar businesses. You have seen so many things like Samsung has filed an application which has already been used by maybe Apple, or maybe Apple has filed something which is used by Samsung. So like these, you see these companies keep on fighting on the different technologies. Why? Because after publication, they get to know, yes, that this is the information which we are using. So for the opposition purpose, for the business purpose, it is very much important, this publication. But in reality, this publication, this only are important to this part, to just for disclosing this information for public domain. But for the exclusivity of right, you will not get any right till it is granted, because granting is the last thing which is required. Because after publication, we are going to scrutinize. This last form is Form 18, request for examination. If you do not file it, your application will still go for the publication, this last form. But It will not go for the examination purpose. Means we will not read your application till it is filed, this formatting. So this formatting is important if you want to go for the complete process. After the complete process is done, you will get to know whether your patent is granted or refused. Granting and refusal is important. If your patent is granted, it means it has the approval from the authority. Publication is just in between process thing. Now the fees. Fees in the patent application filing for the individuals, it is 1600 rupees. Individual means like all the faculties right now I can see on my screen. Now, if you file it by as an individual or maybe a group of individuals, like all of 20 people or 15 people, they want to file it together also, then still the fees will remain 1600 rupees. So the category you can see on your screen: natural person, startup, small entity, or educational institute. Educational institute means, let us assume KCC institutes filing the application. So in that case, the fees will be this: for the form 1, 1600 rupees, form 18, 4000 rupees. For other categories, means any company like Tata Motors or maybe Xiaomi, XYZ, any other company, what they need to pay, the fees will be 8000 rupees and 20,000 rupees. So this is the category. Now the thing is that how to file the patent application. Now there are two ways of filing the patent application. One is the e-filing process, another one is the hard copy filing. But these days, usually people do not go for the hard copy filing because office also do not ask people to file the all the forms and other details in the physical mode. They want that you should file all the things in the e mode itself, means through the website, that is ipindia.gov.in/e-patent filing/go for login. This is the website. So you can go for the this website and you need to just log in. So this will be the login page. Like this, you can just log in the website, and after that you can easily fill in all the forms and other details, and you can go for the further process. Now the expedited file examination. Expedited examination is nothing, just it's a benefit which is given to the people of different categories so that they can utilize their patent as early as possible, because in the past the patent filing and this grant official or maybe the other issues, it may take around 3 years to 4 years for the granting. So to minimize that gap, so that the stakeholders, so that the people should get the benefit from their patents as early as possible, we have categorized some of the people to get the benefit from this expedited examination process. In the expedited examination process, if you come under this category which is written on the screen, like startup, small entity, any of the applicant is a female, means any applicant, because there can be multiple applicants in an invention. So if any of the applicant is a female, then in that case, you can go for the expedited examination. If you are a government organization, so like these, if you come under these category, you can go for the patent, this expedited examination. And in the expedited, what is the actual benefit? That the benefit is that that you are going to get the patent in a very less time, means maybe in a year or maybe in a year and a half. And this is a very less time for any patent, because in any part of the world, if you will find out that it nearly takes around 2 years for any application. So it's a very nice way of filing. If you come under this particular category of expedited examination, then you can get the patent in this in a very less time. Now I think I should talk about other things, means other patent. Instead of about talking about the patent, I should talk about other IPs, because we have a limited time of this particular session. And if I talk about the patent, it will take more than 2 hours to just give the basics of this patent. So I will just brief it down in 5 minutes, other things of the patents. And basic things I have already explained about the patents. After that, I will talk about the other IPs. So in the next, if I say that patents, there are some category in the patent applications which are not patentable, like defense related applications, or maybe atomic energy related applications. These applications require approval from the concerned department. Like we need to refer this application if your application related to maybe ammunition, maybe any pistol, maybe any other type of defense related thing. We will send this application to the DRDO first of all. Now DRDO will give their approval. After their approval, your application will go for the further processing. In the similar way, atomic energy related application will go for that atomic energy department, and after getting the approval from them, we will proceed your application in that manner. Now, the last thing that we need to understand is the process that takes place in the patent application. First thing is that you have filed all the forms 1, 2, 3, 5, 18. After that, after filing the form 18, your application will go for the examination. What does it mean? It means your application got published and we have received your your application for the examination purpose. Now in the examination purpose, when we receive your application, we will do 2 different examination. One is the formal check and another one is the technical check. Formal is just the check of different requirements like forms, fees, and different format, whether you have submitted in the format or not. So these are the checks in the formal examination. Now the technical examination. Now it's a very important thing for any person who wants to file a patent application or who wants to understand about the patent application processing. Technical examination is a very important thing, and not even for a if I say not even for a patent, but for any innovative thought. If a person is having any innovative idea, it's a way to understand whether your idea is actually an invention or not, is we can understand from the technical examination process. Now there are 3 checks. One is the novelty, second is the inventive step, third is the industrial applicability. Can you tell me what is novelty? Novelty. In general, in layman words, you must be knowing about this term, novelty, novel.
Something new.
No, just something innovative or something new.
Okay. So in general, you know that novelty means something new. But in terms of any, in terms of this examination process of this patent, what this novelty means? It means, let us assume that you have filed an application A, B, C. Okay. Now there is a document cited by us like P. And this P has all the information which is there in A, B, C. It means whatever you have filed is already there in a single document P. It means single document is covering all the information which is there in your application. So it means it is not novel. कुछ भी नया नहीं है उसमें. There is nothing new in that information. So अगर आपके जो whatever application you have filed is not novel, it means it is not patentable, क्योंकि that information is already available in any other document. So first thing is that. Now let us assume it is novel. There is no single document which completely discloses about the information you have submitted. Now the second check is the inventive step. Does anybody knows what is inventive step? Inventive step.
Something over and above the existing technology.
Yes, please.
Something over and above the existing technology.
Okay. Then what is the differentiation between novelty and inventive step? Maybe you are correct, but what is the difference between these two then? Okay. So let us assume that I find out that the information is ABC that you have submitted. Now I find out 5 documents, P, Q, R, S, T. Now combining these P, Q, R, S, T, I can come up with the same information which is there in ABC. Because there are so many scenarios that people, what they do, they pick some information from this document, some information from this document, some information from these technologies, and they combine them and they say that this is a new technology and new product. So inventive step is basically the thing that something new and which is not there in any combination of multiple documents which are there, or maybe multiple technologies or multiple products which are there in the system right now in the existing technologies. Means combining any XYZ existing technology in the similar field, we are not going to come up with the same thing that you have filed. So it means that multiple documents we have combined, and still the information that you have submitted, it has something new still. It means it has inventive step. So if you have inventive step in your technology, it means it is novel also, it has inventive step also, it means it has patentability also, means it is patentable. So the difference between novel and inventive step is that we are checking single document, we are finding out single document for that information. In inventive step, we are finding out multiple documents, we are trying to combine them, we combine them and find out that whether the information which is there in multiple documents, and combining them, we can come up with the same information which is there in ABC. So that thing is the inventive step and novelty. Now third is the industrial applicability. Now industrial applicability, we need to understand, like I talk about one case study that I did in the past. Now one person filed an application related to mosquito net. Machhardani, you must have heard. Mosquito net, आपने यूज भी करी होगी घर में. So his invention is inventive as well as novel. Both the things are okay from his side, and we also said that these are okay. But the problem is with the industrial applicability. Now what this industrial applicability mean? It means that it should be useful to the society. It can be applicable to for the industrial purpose, or maybe for the social, or maybe day-to-day usage, and it should not do any harm to the people. Now that mosquito net, what he or that person has, what actually his invention was, he said that I am adding up what I say, a baggage around the periphery of the net. Means on the periphery of the walls of the net at the lower end, he has connected a baggage at the periphery and he filled it with the water. And what he said that because of the capillary action, you must be knowing what is capillary action. Capillary action means water rises up because of the capillary and it goes up and up in the upward direction. Like the similar process that we have in the when we lighten up diyas. जब हम दिया जलाते हैं या वो उसमें जब कॉटन विक लगाते हैं तो वो क्या होता है कि वो कॉटन बिकॉज ऑफ दैट कैपिलरी एक्शन उसमें जो ऑयल है वो ऊपर ऐड होता चला जाता है एंड बिकॉज ऑफ दैट इट गेट्स बर्न और उससे लाइट होती है. तो जो कैपिलरी एक्शन ही सेड दैट बिकॉज ऑफ दैट कैपिलरी एक्शन द वाटर विल गो अप in the mosquito net and because of that the air inside the net will get at a lower temperature. Means अंदर जो हवा होगी उसके अंदर जो नेट के अंदर उसके अंदर हम बैठेंगे तो हमें ठंडक महसूस होगी. So that is a quite possible in terms of mechanical engineering terms. That is a very quite possible process. ऐसा हो सकता है कि ऐसा हो जाए. But the problem with the system is that, first of all, what we have asked that person for the clarity, that right now all the material in the public domain that we have in the with mosquito net is plastic usually. हम देखते होंगे मच्छरदानी ज्यादातर plastic material type की चीजों की होती है. So in the plastic material, this capillary action is not possible. So this capillary, how you are going to do this action or which material you are using, that needs to be clarified first of all. Second thing is that let us assume that walls get filled with the water. So whether you have checked that the person sitting inside is feeling claustrophobic or not inside the net, because the passage of air will get reduced inside the net. So the second question was that. Now the third question was that because the walls of the net will be in close contact with the bedding also. So because of that, what will happen? The bedding will get wet, and in the wet bedding, it's not possible to sleep. So the third thing is also questionable. Fourth thing is that because of that humidity, that water is in quite continuous contact with that person, is the humidity inside that net is very high, and because of that there are chances that the lungs will start absorbing a lot of water, and there is a medical problem that I don't remember the exact term, which edema something, pneumonia or edema something is there, which that person may face after the use some days. So we need the clarity over these things. So there are multiple problems with that particular mosquito net. So we have asked this question with regard to the industrial applicability of that particular invention. Other things were okay. Novelty was there, inventive step was there, but industrial applicability was lacking. So it is very important to understand all the three steps. Now industrial applicability is very important, but in generally it is not questionable. Why? Because hardly there is any information which has all these problems. Means out of, if I say 100, 200 application or 300 application, we hardly see a single application with this type of questions or maybe objections. So industrial applicability is very means a rare objection that anybody finds out in their application. But novelty and industrial applicability is very important for us to understand. Now, after examination, we send you a report that is written, first examination report. After that, this report has all the objections, means all the information, all the things which are there is there in the FER. Now after that, you need to give the reply of this FER in 6 months. Within this 6 months, if you do not file, your application may get abandoned, or maybe you need to file other forms for the clarifications, or maybe you need to pay the penalty for the late filing. Now after that, if all the things are okay, after your get reply, then your patent will be granted. If still some problems are there, we will ask you for a hearing. In the hearing, we will have a video conferencing, and we will communicate, and you need to clarify your objections and requirements in the hearing itself. If your answer is okay, then your patent will be granted, and if still there are some issues, then it may be rejected after hearing. So this is the complete process of the patent application filing. So this was all about the patent application. Now, do we have another 5-10 minutes for the session?
Yes, sir.
Okay. So I will just talk some basic things about the other IPs, and we will wind up the session. Now the second IP that we have is the designs. Now that is a very big difference between the patent and the design. Now in the patent, we were talking about technology, or maybe any innovation, or maybe any solution that you are giving to a prior art. Now what is design? Design is basically any aesthetics of any product which is new, means any product which has a new aesthetic, new looks, basically comes under the design. What is the basic function of this design? Design is a very important aspect for any product. Why? Because we can have multiple products with the similar specifications. Now I will show one example. Now on your screen, you will see 3 cars which are there. Now Ertiga, S-Cross, and this is Brezza. These 3 cars have the similar technology, they have the similar engine, they have the similar output, everything is similar, but the outer looks are different. So some people say that I want to buy this one, some people say I want to buy this one. Why? Because of the outer looks only. So that comes under the design part, the outer looks or aesthetics. Now, what is the industrial design? Industrial designs means any shape, configuration, ornament, or maybe the combination of colors, or maybe lines which are solely judged by the eyes. Means आपको आंखों से देख के जो differentiation नजर आ रहा है, that is only protected under the industrial design. Term of protection in design is 10 years. It can be extended up to 5 more years, so that is 15 years. So that is the total duration in the designs. Now, the next IP that we have is the trademarks. What is a trademark? Can anybody tell me what is a trademark?
Trademark is a type of logo or a sign which represents an organization or an individual which is registered with the government and has a right to print on particular items, and the company or an individual has right to show his logo, and it can be showed by the company that this material is made by us, or this product is completely from our side.
Okay, so your answer is quite right. Another addition that I want to ask, what is the actual functionality of this trademark in this world?
Sir,
Means what is the benefit? Like, let us assume that you have a company, or maybe KCC Institute. Now KCC Institute has a trademark. What actually it means to the public?
Basically, it is used to different us from others.
Yes,
Means,
yes. It means, yes, you are right. Means it is an identity to your product or your company or maybe your whatever it is. And it is also what I can say, the differentiation between the quality and the other things also. So all the things are linked with the trademark itself. So if you are going to start any business, this trademark registration is one of the important aspects. There are two things that we need to understand. You can create your name by time or by this recognition or maybe different sign. By time, what I mean, like if you have established any shop or maybe any work at a particular place, maybe after 2 years, 3 years, 5 years down the line, people start knowing that this place, this people is very good in their work. But if you have a particular very good trademark, means if you have a very recognized name also, if you have a registered trademark, then whenever you sell your product in the public with the same trademark, then people across the city or maybe across the nation will definitely know that this product I have seen at this place also, with these people also, with that people also. So it means it has some good quality. So that is also useful to your business, means for expanding your business. So this trademark is very important in that aspect. So what is actually a trademark? Trademark means any word, name, symbol, or maybe combination of these, all these things, which identifies, distinguishes the source of goods and service providers to that of others. So that is a very important aspect for any business. Recognition, you must be knowing that registered trademark means R must be written over that bottle or maybe whatever product you have seen, like Bisleri bottle. Now after Bisleri, you must be seeing that R is written over there. So what it means, it's a registered trademark. In the similar way, if TM is written, it means that person has filed for the registration of the trademark and the process is still going on. Now, copyright is basically a right, legal right, which is given to a artistic or literary work like books, writing, music, painting, sculpture, film. So like this is right related to the authors or maybe the music industry or maybe different art forms. Now, in the copyright, we need to understand one basic thing, that because there are many categories in the copyright field. So each field has different fees and different duration of that protection also. Means if I say the fees, literary work, dramatic, artistic, it has 500, artistic in a particular category 2000 fees, sound recording 2000, cinematographic 5000. So this is the fees. Term of protection that I was saying, that published work means any book if you have written and you have the copyright protection over it, then it can be up to the life of the author plus 60 years. Cinematographic films 60 years, broadcasting 25 years, performance 50 years. So like this is the term of protection in the copyright. Next is the SICLD. Anybody ever heard the term SICLD in the past? Semiconductor Integrated Circuit Layout Designs. What is SICLD? Okay, I'm showing you this slide. Can you give me the differentiation that why SICLD is not in the category of the patent? First and second para has all the information. what is the differentiation between the patent and SICLD? I'm just want to ask if you can understand from these lines. Okay, no, not an issue. So because it's a very I myself, when I understood about the SICLD, my first question was to myself and other people's like, why it has not been added to the patents, and what is the actual differentiation between the patents and this SICLD. So the answer is that SICLD is not the protection over the technology. It is not the protection over the technology. It is the protection over the layout, means how you have configured or put together different elements of the electronic circuit in a particular device. Means let us assume this is a mobile. In this mobile, we have different things, like we have a camera here, we have a fingerprint touch sensor in the front, we have a camera here also, front camera. Now in some mobiles you may be using, some people have a camera at the center there, some people have a fingerprint touch sensor at the back, some people have a front camera at the side also, some people have a camera on the pop-up where the camera comes out from the mobile itself. So what it means that how you have put all the different elements of the electronic circuit in a device. It is basically the protection over this SI. Through this protection, we are going to get in this SICLD. You can read the second para. Layout design means layout of transistor and other circuitry elements includes lead wires connecting such elements as expressed in the manner in SICs. So SIC is basically the protection of this layout design, how you have put all the different elements in a particular device. Now the last IP that we have is the geographical indication. So what is a geographical indication? Geographical indication means any product which belongs to a particular specific geographic origin and poses a quality and reputation that are due to that origin only. Means there is maybe climatic condition is different, the soil is different, maybe the people who are growing it, or maybe their art form is different. So because of all these different things, all these different aspects, the product is completely different from other places and make it a special product, or maybe of different qualities with different things. So it is basically the protection of that art or maybe of that product. It is not given to any individual. This right, geographical indication is not given to any individual. It is given to a group of people, or maybe a city, maybe a state, like this. You must have heard about Banarsi silk, maybe Kanjipuram silk, maybe Kesar from Kashmir, maybe oranges from Nagpur. So these are what? These are the different products from a different places which has some speciality because of that different aspects like climatic condition, how they are being grown, or maybe the art is performed, or how the different things. So this is basically the geographical indication protection. So these were the different IPs that we have under the protection of IPR rights in India. Now, if anybody has any questions, you can ask me now and we will end the session there. Anybody has any questions or queries?
Good afternoon, sir.
Yes, good afternoon.
So my question is actually related to the digital signature, which is issued by EU Mitra.
Yes,
As
yes.
you show in your PPT also, okay, like this is the, the we need a digital signature.
Of
So
second and third category. Yes, yes.
yeah, yes, sir. Okay, before filing this, we have some, requirement. So I have two queries regarding to the digital signature. The first one, if you will going to apply for the digital signature, is there is an amount by the government? And the second one, sir, is anyone can apply for this digital signature, or there is a few, parameters after that,
So
or
no,
some
I don't
eligibility
think
area after that we can
there is
apply.
no such parameters. Anybody can file for it, I think. And there is a, I think, some fees like maybe 2-3 thousand. I don't know the exact amount, but there is a fees linked with that digital signature.
And sir, is this digital signature is applicable in all country? Like if I'm going to apply for some other country patent, so
That
can
I don't know, because filing in other countries, each and every country, their filing process is different. So that I cannot be sure, because I already in the starting I said that it's a state right. So maybe the documentation, the forms, each and everything can be different in each and every country. One thing is there that I have not explained. Like you may be having some thought related to the, like, some people have said that I have a global patent. Did you have heard anybody saying that I have an international patent or global patent?
no, sir?
Okay, maybe, but some people have a thought in their mind, like they say that I have filed a international patent, but there is nothing like an international patent or anything which means that you can just file on some platform. Like PCT is basically a process of filing the international application. So in that case, what happens that international filing process is different. It comes under the PCT that someone has said in the starting, something related to the PCT Patent Corporation Treaty. There are some countries, around 144 or 150 countries were there in this treaty. Now, if you file through this PCT process, you are eligible to file that particular application in all the different countries which are under this act. Now, the thing is that after that filing of international application, still you need to go and you need to fulfill all the requirement of that individual country. It's not like that you have filed on that platform, all the things are over. That is just the way of filing the application, international filing process. And you just get one benefit is that you just need to fill one form that in these countries I want to file the application. Like you just select the 10 countries from that form, and your application will be automatically go for the further process. And the timeline is also different in that process also, so that is also a benefit in that international filing. But you need to forms, whatever the other requirements are there in that particular countries. Like in India, I have told you these forms, and maybe some other documents also may be required if you are filing through the help of attorney or agent. Then you need to file the form 26 also, or maybe the power of authority. So like these, there are some other requirements. So in each and every country, the filing process is different. So I cannot give you the real answer that whether it is useful in other country or not. That is not clear to me also.
Thank you, sir. Sir, I have one another question. If someone file a patent in like on any topic, or either design or utility patent, okay. So can anyone else can file a patent in another country with the same topic? Is it
No,
possible, sir?
no. Actually, it's not like that you have filed it in US and now somebody else copies it and file it in India. It is not possible. Why? Because all the documents, all the things are uploaded on a public platform on worldwide level. No, it's not like that the information will remain in that country only. If an application is there in US, we can also see that application in India also. And our databases check all the information from all across the world. It may be a chance that there are some written information which is not there in countries like US, UK, or maybe some other countries. Like you must have seen in the case of Neem and Haldi, you have heard that they got the patent over some products related to Neem and Haldi. Someone has filed the patent application over it. This thing has happened because they do not have the information data related to that information. But after that, patent was revoked, and after that, what has happened? We have shared our TKDL, means traditional knowledge related information, to the other countries where they can see all the information written in the Ayurveda and other things. So it's not like that you file it in this country and other people can copy it and just file it in another country. If that happens, it means you can file the infringement case against that person in that country. You can easily file that thing. You can file a pre-grant opposition against that person. If that
Thank you, sir.
happens also.
Thank you, sir. Thank you so much, sir.
Is any other question?
Good morning, sir.
Good morning.
Patent search, is it necessary to perform patent search by the candidate before filling the patent?
It's up to you. If you believe that your information is very new and you already know all the things related to the previous technologies and the things which are going all across the world, you are pretty much sure about your information, then you need not to do the search. It's as simple as that. If you have any doubt that maybe because we are thinking the same thing here, or maybe someone else is also having the same idea in any other country also, not only in India, in other countries also, the similar ideas, similar informations were going through in the different people's mind. So maybe they have already filed a patent and just maybe within few months back, they have filed it and you may not be knowing it. So it's good if you can do the search. If not, and if you are sure about it, then you just file it. We will definitely give you the answer over the things after the examination, whether it is patentable or not. If you can do it by yourself or maybe with the help of any other expert, it's very good to do it because it will help you out in understanding the upcoming processes also, that what answer you need to put up if this type of queries will be asked related to the prior art.
Thank you.
So the information provided by you is very nice and it is very helpful for us. I have a question. So in case of book or study material, there are some particular case studies or there are some particular examples which are very fixed in nature. So if we incorporate in our study material like book or lectures or video lectures, will it be in Copyright Act or will it be considered for
information? First of all, if you see that any information, any paper or anything, you will find out that whenever someone copies any data from some place, they will definitely write down in the end that they have taken it from this place. But yes, definitely you can incorporate all the information from different places in your paper or maybe your book, but you have to mention it in the end, or you need to re-explain it maybe in other words also. So that is okay. But just copying it completely and just putting it in that paper or maybe book, it is not okay. And you are not taking their prior permission also. So that is very
example,
yes.
For example, there was a mathematical question and the formula is same, even the language may be approximately same. But if we are changing the digits, we are changing the programming in a particular code, then it will be good for copyright, or it will be under consideration of copyright?
Uh, First of all, related to copyright, I cannot give you the exact information because copyright is a completely different thing. And we are working in the patents, and all fields are very much specific, and the information that you are asking are too much means related to the very complex part. Maybe I can just give you the basic information related to the copyright. Exact information I cannot give because the processes of each and every IPR is completely different. Understood? Patents related thing I can easily clarify and I can give you the exact answer about that thing. But related to copyright, I cannot give the exact information whether it is okay or not. But the basic thing is that I have already told.
Thank you.
Good morning, sir.
Yes, please. Good morning.
Hello.
Yes, please.
I have a question. Can an invention be patented after publication or display in the public exhibition?
Yes, please. Please, can you?
Can any invention be patented after publication or display in the public exhibition?
No. Means there is a provision in the act, but from our end, I just say no, because there are complexities with that part. If you show it in any means government exhibition or then in that particular art place, then you need to give multiple clarification and other things. So the simple answer is no. But there is a provision in the act, like in some places or in some government exhibition, if you show your information, then it is still not counted as a published thing. But in reality, what the thing is that, or what you should understand from this thing, that you should not publish it before filing the patent application anywhere, or maybe in any publication also.
Okay, sir.
Understood? Means you should first file the form 1 and other details in the patent office. After that, you whatever you want to do after 1 day, means after filing form 1 and other forms in patent office today, tomorrow you can do whatever you want. You can publish anywhere, you can display anywhere, whatever you want to do, you can do it. But just do it after filing of the patent application.
But sir, I have seen so many person they have published the research paper, and after that they are filing the patent of the same topic.
So you will find out that their patent application will definitely get rejected. They file it, but their application will get rejected after the examination process, because their same document will work as a citation for their information.
Right, sir. Means we cannot refer our research paper for patent filing.
No.
Okay, sir.
Good afternoon, sir.
Yes, please.
My question is related to the trademark. Can trademarks be transferred or licensed to the other parties?
Yes, please.
Can trademarks be transferred or licensed to other parties?
I think yes. But what
Sir, what is the difference between the transferring and licensing a trademark?
I just told you in the between of the session that related to any other IPs, I cannot give the clarification correctly, because all the other fields are very different. Each and every part is quite different. So, and knowing all the information related to each and every part is very difficult. If I say that any part about any other IP also, then maybe the next question may be the forms, or maybe the fees, or maybe other things. So it will be better that if you have any queries related to it, just mail it. I will refer it to the exactly correct person so that they can give you the exact answer. Any queries related to patent, I can clarify.
Okay, sir.
Any other queries? I think it's already 12, so I need to go. So if you have any query, you can just message me, or maybe through the ma'am, you can just share me on my number, or maybe you can mail me. I will try to answer them through the mail.
Can you share your email ID, sir, please?
In the chat box, wait, I will try.
Yes, sir.
So I have written it in the chat box. Just if you have any query, you can just mention it there, and I'll try to answer it afterwards. So
Thank you so much, sir, for joining us today. And participants, if you have any doubt, you can kindly mail sir whatever the questions that you have regarding the patent. Am I audible, sir?
Yes, yes.
So on behalf of KCC Institute of Legal and Higher Education, I, Nidhi Gandhi, Faculty of School of Management, extend a hearty vote of thanks to sir for taking out time from his busy schedule to grace the program with his presence and enlightening us with your knowledge and understanding. It was a great opportunity to hear from you, sir. Thank you once again for showing your presence today with us, sir. Thank you so much.
Thank you.